I'm very happy to be here amongst so many young talents and lawyers and activists from different parts of Southeast Asia and also from different parts of India. And I've been asked to say a few words on how to combat injustice with law. This is a very, if I may say so, a very challenging topic. It's the topic of eternal relevance, in the sense that I have associated the best years of my life in the field of law. I've joined the legal profession in 72. Now it's 2013, almost 40 years of being there. Sometimes as a lawyer and then sometimes as a judge. And now that I have retired in 2012, but even then I'm continuing willy-nilly in the field of law as the chairman of Human Rights Commission. See, the position in our country, the biggest democracy in India, certainly the biggest democracy in South Asia, is the Indian, I would say Indian subcontinent, if you permit me to say that. That there is a marked change in the legal regime between what we had during the British days and then what we have today, I mean with the beginning of the Constitution. In the British days, our legal system was virtually established by our colonial masters. You remember that with the assumption of, if I may say so, assumption of governance of this subcontinent by the Queen Victoria, after the Sepoy Mutiny was somehow or other quelled. That is, I'm talking about divided India in 1857. Immediately thereafter came the different high courts by the Queen's Charter. The latest patent must be knowing, one in Calcutta, one in Mumbai, one in Madras. The name of the cities have changed, but the name of the High Court has remained the same. And that time, a very important High Court was established in Lahore, which is the precursor of, I think, the Supreme Court of India. That was the main High Court, from which we had Punjab and Haryana High Court, then Delhi High Court, and then Supreme Court after the Constitution came. But in northern India, Lahore High Court was the major seat of justice in those days. Now, along with that establishment of different high courts came different laws which are still governing us, like Evidence Act, Penal Code, Transfer of Property Act, Contract Act. They are virtually the same in both in the subcontinent. So this present law regime under the British common law principles came to be established in those days, and it went on and on. And the main principles of the British masters in enacting law, there are two different kind of systems. One for the natives and one for those who are the original inhabitants, the original Britishers. That is what is meant by the original side jurisdiction of these high courts. The place where the Britishers stayed, a different kind of procedure was followed there. But that is still continuing in India. I don't know what is there in Pakistan. That some original side jurisdiction still retained in some of the high courts. But of course, with Indian laws and Indian judges and Indian system. This was they made two different kind of adjudicatory process. And the most important writ, which is known as the writ of habeas corpus, under the British India, habeas corpus was available initially within the original jurisdiction. That means those who are resident in that area, they will get the benefit of the writ of habeas corpus. But later on, of course, it has been made available throughout the country. Now, this was the position. What are the striking feature of this British system of law? They were mostly concerned with the concept of rule of law. Rule of law means an authority which is to administer the different legal system, the different provisions, and the basic rights, your civil rights, criminal rights, were decided by enacted law. But what is known as the liberty of the people, on that aspect, the colonial masters were very, very rigid. But there are some judges, I must say among them, in Calcutta High Court there was a judge called Lord Jenkins. He was one of the finest of judges, and he used to uphold the torch of liberty. There were some exceptions. There such exceptions were there, Justice Suleiman and all these kind of judges, who used to use the legal procedure, the legal system, to usher in an age of the spirit of liberty. But when the Constitution came after the independence, and the Constitution was being drafted, the law regime completely changed in India, at least on paper. Because the Constitution of India has a radical element in it. It's very radical. While introducing this Constitution, Pandit Nehru was one of the architects, said and summed up the spirit by saying, we have a Constitution which is going to liberate India. Kindly see, Constitution liberating a vast country. And he said the purpose of the Constitution is to feed the hungry millions and clothe the naked nations, naked people. Therefore, that was the two basic purpose of the Constitution according to one of the main architects, to arrange for the basic necessities of people. One is food and the other is clothes, and of course the liberty. So this was the three main message in the Constitution. And the constitutional provisions are made for that. You see, when the Constitution was started, the preamble started with the words, we the people. You must have seen in the Indian Constitution. That is possibly borrowed from the American Constitution, where also it started with we the people. But India is a land of gods and goddesses. India is a land of leaders. You could have started the Constitution in the name of any one of them, or in the name of any one of their leaders whom they consider one of the almost on the pedestal of God. But they started with the word we the people. And the way the Constitution is framed, he said it is not imposed on them. We adopt. We, the people of India, adopt. That means there is an element of choice. There are various choices open to us. We are adopting this Constitution. And what does it say? Because the preamble, which is the essence of the Constitution, which is the essence of the Constitution, though it starts at the beginning, it was drafted at the end. After the Constitution has been more or less framed, the preamble was drafted, which sums up or epitomizes all the principles in the Constitution. It says it has three parts. The preamble has three clearly demarcated parts. First is, we resolve that we adopt this Constitution. One is resolution. The second part is that we assure, this Constitution assures to the citizen certain things. And the third part is a declaration that it will come to effect from such and such date. The most important thing is the second part. that we resolve and adopt that India is going to be a secular, later on it has been added, secular, socialist, democratic republic. These are very important words. Secular, socialist, democratic republic. And we assure, what is the things assured? Liberty of thought, belief, faith and worship. Equality of opportunity and status. Fraternity. And the most important, the dignity of the individual. And they have equated under the Constitution. This is the most important in the present day context. The dignity of the individual is equated with the unity and the integrity of the nation. There is a famous thought, and very rightly so, that if we have a country of people whose dignity is denuded, who has not been conferred within any individual dignity, any liberty, then you cannot have a strong nation. The unity and integrity of the nation depends on the dignity of the people, the dignity which is conferred on the people. A people who is not given dignified class of living, dignified standard of living, cannot be united, cannot be integrated. That is the basic idea, which is today departed, unfortunately. But the dignity of the people, in the name of so-called security and so-called integrity of the nation, is being denied every day. So that is why the famous constitutional expert and jurist, Mr. Palkiwala, said, our constitution is a charter of liberty. And this charter of liberty has granted some power. It is not a charter of power granted by liberty. It is a charter of liberty which has granted some power to the state to curb the liberty. Certainly it can be curbed in social interest. It is not a charter of power. Therefore, the liberty is the basic spirit in the Constitution. If you look at the preamble, how does it read? Liberty and justice. Justice of the widest variety. Widest variety. Of all variety. Because the famous thought that if there is no social and economic justice, especially